Friends, we now continue to understand what the challenges of drafting are. Now, if you look about in the previous discussions, you would have learned that drafting is a synthesis of law and fact. It tries to convey in coherent terms what the actions of each of the parties are to be. Now, in that aspect, there are certain inherent challenges that the law poses before you. Because at the end of it, a contract is only an agreement which is enforceable by law. And the inherent challenge that lies at drafting is creating or framing of a clause that does not get implicated or vitiated by the law. On this point, we will come to a discussion on an aspect called restrictive covenants. I am sure you must have learned this in the previous discussions, but we will look at it from the perspective of the challenges that drafting holds onto restrictive covenants. Restrictive covenants are always on the journey, in the sense that with every passing year, you come across a new form or sort of restrictive covenant, something that tries to create a binding nature on the parties between a contract. Now, if you would ask me what restrictive covenants inherently are, a restrictive covenant is something that asks a person to do a negative act. It, in the sense, it puts across an obligation for a person to abstain from doing a particular action or refrain from doing a particular action in a particular manner. Now, with the particular years, I would just like to bring about two instances where certain new restrictive covenants came across as wildfire. The first discussion that we'll be taking about is the Infosys story of 2018. I would just take you back in time to 2018 when there was a crisis which unfolded in the top level management of Infosys. What happened was that the founder of Infosys and the then managing director of Infosys had an ideological clash. This ideological clash brought about a particular requirement that the then managing director had to step down from the company. Now, in that pursuit, came across a discussion on something called a non-disparagement agreement or a non-disparagement clause. What would you understand by what a non-disparagement clause is? Please look at the conflict that was there in hand. This is a company which has been pivotal in the development of India's Silicon Valley and India's software system. This is a dispute between the top level management of a listed company. Any amount of information that gets breached into public domain owing to this dispute by either of the parties is almost going to set a huge setback for the company, its reputation, and all the people who are associated with it. On that ground, there was a particular rumor that a non disparagement agreement was executed between the top executives. Now, to understand what a non disparagement agreement is, please note it simply puts that either of the parties who are executing the non disparagement agreement or who are signing to or consenting to the non disparagement clause cannot in any manner create any hindrance or disrepute to either of the parties to the contract. That is what essentially a non disparagement agreement puts across. It tries to ensure that the reputation of either of the parties does not get vitiated merely because one person decides to take the matters to the press or to any other third person. The second aspect for today's discussion on restrictive covenants comes across to the Wipro story of 2022. As you may see, the Wipro story of 2022 brought about the aspect of moonlighting. You may ask me, what is this aspect of moonlighting? Please note, friends, moonlighting is one of the aspects of ethical misconduct that Wipro highlighted in several of its employees. What essentially the employees did was, although they were a full time employee of Wipro, After the office hours, they went ahead and carried out certain personal errand or personal avocation of some sort or the other. It could be a startup idea, it could be working together on a different project or otherwise, which are not in the interests of Wipro. Now, one of the ethical combats that Wipro brought about in justifying the action of firing most of its employees who were engaged in moonlighting was that Wipro had in its mind that moonlighting will affect the performance of the employees in giving their services to Wipro. While on one hand, this is the story of Wipro, on the other hand, you will notice that the employees' contention was that although I am bound by Wipro's employment, I am carrying out all my personal activities after my employment hours. I think that has nothing to do with Wipro. So, this is the ethical combat that was there between the management and the employees in the 2022 story. But, my friends, look at it from this perspective. Section 27 of the Indian Contract Act is quite clear. It speaks about agreements in restraint of trade or employment. And please note, my friends, as long as a employment contract is valid, restrictions can always be imposed during the tenure of employment and not beyond it. So even though moonlighting is brought about the kind of ethical dilemma that the employees carried out their moonlighting activities or carried out their personal avocation beyond the working hours, it was nonetheless during the subsistence of their employment contract with Wipro. And as such, the implementation of the moonlight clause or repudiation or termination of the contract citing moonlighting by its employees was an absolutely valid action as long as the other procedures are also duly carried forward. So these are the aspects that come across on the points about how contractual clauses are evolving over time and as to how draftsmen have to be on their toes to keep in light the new advancing changes. With this, we move on to the second leg of restrictive covenants that relates to your employment bonds or service contracts. Now, one of the essential aspects is with regard to the implication of fundamental rights in your employment bonds. This is a particular aspect that particularly relates exclusively to government contracts, employments with the government, or with any particular public sector undertakings where the government has a substantial hold. The Supreme Court in the year 1982 answered categorically that fundamental rights are something that can be imposed on government employment or contractual activities with the government. Fundamental rights cannot be alienated merely because the government is carrying out a economical activity. It was held that it is the duty and the bounden requirement or obligation of the state to ensure that the fundamental rights are meted out at all times and including in those natures where the government carries out employment activities as well. In the case of Air India versus Nargesh Mirza, it so happened that Miss Nargesh Mirza was an air hostess. The contract had stipulated certain conditions on basis of which, on the completion of a particular age, the air hostess could be terminated from service. It was a stipulation of the contract that air hostesses were to retire on the first pregnancy and on marriage within 4 years, and also retirement at the age of 35 years, extendable up to 40 years. Now, please note this was the particular contractual clause that was there in the agreement which employed air hostesses in Air India. Now, if you look at it, Nargesh Mirza took it quite intrigued and felt discriminated merely because of the particular requirements. She was of the view that these obligations that were cast under the contract were something that went inherently against her fundamental rights. The right to have a child the right to be married, and of course, the unmeasurable or undeniable right to grow old. Age of a person cannot be stopped at any count. That being the premise, a petition was filed challenging such contractual clause, stating it to be of arbitrary in nature and against the fundamental rights. Please look at it, my friends. Look at it from the perspective of the employer also. Air India, on the other hand, had certain justifications as to why they had imposed these conditions. On the aspect of first pregnancy, they mentioned that, see, pregnancy is a medical condition, and inherently there are certain medical factors that are associated therewith, and as such, any person who has the effects of pregnancy will not be able to go ahead into the part of the flying crew, and as such there might be a requirement for the air hostess to retire because essentially she is there on flight crew duty. The second aspect that was put across was with regard to the marriage within a particular period of 4 years. Now, if you look at it, the aspect of marriage, it was brought about saying that, see, the flight crew has a very stringent requirement or timing requirement to travel at odd hours, which may not be possible in case there is a matrimonial issue that is involved. So, as such, on basis of those particular counts, it is suggested that within a particular period of 4 years of marriage, the retirement is required to happen. And while at the same time, if you look at the aspect of the age limit of 35 and extendable up to 40 years, it was suggested that this is how the service industry is. If you look at it, there is a requirement for the age of the air hostess to be kept in mind. That is a special industry that is kept in across, and as such, it is on par with the other competitors. And we are not doing something that no other competitor has not done. So, on these grounds, Air India sought to uphold the particular contractual clause. But look at the marvelous manner in which the courts interpreted the clause. The courts categorically held that such a clause was arbitrary and against the fundamental rights of every woman. They proved that they proved that as an employer, the government should set a benchmark for other participants in the market. They cannot state that market conditions are of similar nature, and as such our contractual clauses are also valid and they can also violate fundamental rights, because in no juncture fundamental rights can be violated by the government at any cost, even though if such particular violations occur because the government is carrying out an economic function. On those grounds, it was held that such a particular clause in an employment bond, especially with that of a government entity or a public sector undertaking, cannot be withheld as valid, and as such, it has to be struck down. These are the challenges, friends, which comes across when you're going about drafting of a contract. Merely the change of how a business entity is formed, the nature or source of its funds through which it operates, can categorically amend the manner in which the courts will view the contracts. Now, had this been with a private player, the implication of violation of Part 3 of the fundamental rights would never have become an issue before the courts of law. So, as such, depending upon the type and nature of the party, the contractual drafting style also has to be modified, and this is one of the biggest points which you should take forward while going ahead with drafting of contracts.